Okay, good morning, class. Today I'm going to be recording your finals. So make sure that you access your speed building beforehand. And then that you're now listening to this, make sure you have your EV360. And just remember, you're going to have access to EV360 during the break. So if you're enrolled in the class, you're going to have access to EV360 during the break. So I'm going to start with 1 minute at 180 warm up for your lit, okay? Here we go, 1 minute at 180. So the deficit increases. Under this amendment, Congress would then have to make up the difference with measures that will stifle the economy even further. That is not good economic policy, and it will have extremely serious consequences for ordinary Americans. It will mean lost jobs and lost wages, and quite possibly could send us into another Great Depression before we would know what hit us. Having lived through the Depression as a child, I can tell you that is something to avoid like the plague. Let me discuss another aspect of this amendment that will take us backward. The amendment proposes to balance the budget by raiding the Social Security Trust Fund. Social Security represents a sacred trust between the government and our citizens. Often it is the mainstay of retirees. We have made a commitment, virtually a contract, with the men and women who have been paying into that trust fund, and so it is critical that we keep it off budget. If Congress spends too much on welfare or the military or farm programs, or if we give too many, and you have on your 180 lit number 1 mock, you have Bay Area, San Francisco, and Noe Valley. I'll just say no to make it easier. No, that's probably how it's pronounced. This is going to be 180 lit for 5 minutes for your mock. This is a case study about a famous attorney who was working back in the 1940s in the Bay Area. One night in San Francisco, there was an armed robbery that took place at a jewelry store. The jeweler who was robbed at gunpoint did a lot of work with gold, and he worked out of the back of his store at night once the store was closed for business. He worked alone most nights. He had set up a shop in the back of his store where he would work many nights of the week making the items that he sold in his store. He worked with both gold and silver and had a reputation for being excellent at what he did. His work was known all over the Bay Area, and the rings he created were world-renowned. Many of his rings were bought up by the celebrities of the day, and that brought in a very good income for the jeweler. Now, in order to make all of these rings and other pieces, he had to use a lot of heat to melt down the gold and silver. He used some kind of a torch in order to heat up the gold and silver to the melting point that it needed to be at in order to work with it and be able to shape it into rings and that sort of thing. One night while he was in the shop at the back of his store, he was held up by 2 men who were armed with guns. During the course of the robbery, the jeweler was shot and killed. When the police arrived at the scene, he was already dead, and there was a gun found on the floor of the shop. Well, it turned out that the gun didn't belong to the jeweler. So the police, of course, surmised that the gun had to belong to the suspect who had shot and killed him. Within a few days of the shooting, a suspect was picked up by the police. It had been discovered during the investigation of the crime that during the course of the robbery, there had been some hot wax spilled out of a mold and onto the floor of the shop. The hot wax was used to form jewelry, and it was found spilled over the floor of the shop. Well, it just so happened that the suspect the police had picked up had a burn on his left hand, and it looked like it was quite recent. The suspect was charged with murder and armed robbery, even though no one had seen him commit the crime. The suspect then hired one of the very best attorneys in the Bay Area to help him with his case. He told his attorney that he was innocent of the crime and that he could prove that the burn on his hand had occurred days before the robbery took place. According to the suspect, he went to a wedding right around the time of the robbery. He said there were photos of the wedding that would show his left hand with a burn on it. The wedding took place 5 days before the robbery. so he felt he had an airtight alibi. He told his attorney that there were many people at the wedding who saw him and who asked him about the burn on his hand. He said that one of the guests who had asked him about the burn on his hand was a minister in No Valley, and that he would vouch for the fact that the burn was on his hand at the time of the wedding. After hearing that, the attorney was convinced of the story, and he took the case on, and he agreed to represent the suspect in court. Then he went out and began to check out the facts. He went to the minister to talk with him, and he went to see some of the friends of the suspects. None of them could recall whether or not the suspect had the burn on his left hand at the time of the wedding. He then went to take a look at the photos of the wedding, and he saw that the man's left hand never once appeared in any of the photos taken on the day of the wedding. In fact, in all of them, his left hand was always placed in such a way that you couldn't see what the hand looked like at all. Well, about the time that the case was set for trial, the attorney was getting ready for the big showdown when he began to hear rumors from some of his friends that the police had the gun that was used in the crime, and there was a fingerprint on it that matched with that of his client in the case. Remember that this was in the 1940s and years before the current laws of discovery. Back then, the defense didn't get all of the exhibits to look over before going to trial. The attorney couldn't go to the police and force them to hand over the gun, and he couldn't check to see whether or not the fingerprint of his client was indeed on that gun. You see, back in the 1940s, things were, and then we have 1 minute at 200 jury charge for practice. In doing so, you may take into consideration the interest, bias, or prejudice of any witness. You may also consider the demeanor or the behavior of the witnesses upon the stand, anything that is in the record that will aid and assist you in evaluating the testimony of the several witnesses who shall testify in this case. So you can readily see, ladies and gentlemen, that it is your duty under your sworn obligation that you have taken as jurors to please pay close attention to the witnesses, listen to the attorneys, and to the court. Do not let your thoughts wander and your eyes rove around the courtroom, but rather give strict attention so that at the conclusion of the case, you will be in a position to determine what the true facts are and apply those facts as you find them to be to the law as I shall charge it to you at the conclusion of this trial. And you will thereby arrive at a true verdict in accordance with your oath, which you were given earlier today. That is what the word verdict means. It is derived from the Latin phrase veredicto, meaning to speak the truth. Now, I do not intend, ladies and gentlemen of the jury, that you or anyone else should construe these remarks, which I loosely call my preliminary remarks, as a charge on the law. And then you have on your jury charge, proper names, you have none. Okay, so no proper names. This is going to be jury charge test for your mock number 1 final exam for 5 minutes. Members of the jury. In this case, the plaintiff contends that he was unjustly apprehended and charged, and the prosecution lacked probable cause for this. By this action, he seeks to recover compensation for damages he suffered because of what he says was done to him by these defendants. The defendants contend that they are not responsible for any damage that may have been caused. During the course of this trial, it was the duty of the court to deny some of the motions made by counsel for the defense to dismiss this action. By that, you jury members are not to assume that the court has an opinion one way or the other about any of the facts in this case. Under our system of jurisprudence, the duty of the court and the duty of the jury are divided. As it is, we have set up a natural barrier between the court and you members of the jury. The jury is the judge of the facts and only the facts, and the court decides the law that is applicable to the facts of the case. You might have ideas of your own as to what the law should or shouldn't be or what the law is. And you may have gathered from the remarks of counsel during the trial what their opinion of the law is as well. Bear in mind that because we separate the duty of the court and jury, you will dismiss from your minds what counsel told you the law is or what the law should be. And even if you don't think it is a good law, the court says to you that you must take the law from the court. In this case, the plaintiff has the burden of proving to your satisfaction by a preponderance of the evidence that his arrest and prosecution were by the direction of the defendant, and furthermore that they acted out of malice. He must prove to you also the damages which he claims to have suffered. He must establish these things by the credible evidence, that is to say, by evidence that proves the facts. If he fails in that, he has failed to prove his case, and he may not have a verdict. Before you can have a verdict in this case, you must find that the defendants did instigate the arrest and prosecution of the plaintiff. The action of the defendants as they claim is giving information to a police officer when called on to state facts and does not in and of itself make them conspirators in action with the police officer in making the arrest. Unless you find that the action of the police officer was instigated by the defendants and that the officer acted not on his own volition but acted to carry out a request by the defendants, then they would not be liable. From the time the plaintiff was taken into custody by the officer, he was subject to the control of the officer, and neither of the defendants had at any time thereafter a right to require the holding or the release of the plaintiff, and they cannot be held liable for the exercise of judgment on the part of the officer. If you, ladies and gentlemen, find that the defendants did nothing more than give information to the police upon which the police later acted, and that even though there was a mistake in the information, the defendants acted in good faith and only for the sole purpose of helping the police apprehend a person who they thought was guilty of a crime, then your verdict must be in favor of the defendants. To warrant a verdict in favor of the plaintiff for false arrest, you, ladies and gentlemen, must find that the arrest was unlawful and that the arrest was not based on any kind of probable cause. Lack of probable cause doesn't mean a lack of any cause before you can rule in favor of the plaintiff. However, he must prove to you by a preponderance of the evidence that not only was his arrest unlawful, but that the defendants acted without probable cause. The burden of proof is on the plaintiff in regard to all of the facts in this case which you are to consider. The plaintiff must satisfy you of each fact needed to make his cause of action to you. That means that each fact which has any bearing on the cause of action in this case must be proven to you by what is known as a preponderance of the evidence. Preponderance of the evidence doesn't mean the number of witnesses one side has as opposed to the other side. It isn't about the quantity of the testimony, but the quality of the testimony. The plaintiff has the burden of proof as to every fact that makes up the cause of action, and if he fails to do so, if the evidence does not preponderate in his favor, or if the evidence is evenly balanced, then the jury must return a verdict for the defendant because the plaintiff has failed to sustain the cause of action in this case. When it comes to the question of the credibility of the witnesses, you members of the jury are the sole and exclusive judges of the credibility you will give to the witness's testimony. You are to decide what the facts are in this case based on the testimony of the witnesses and the evidence in the case, and nothing else that you may have seen or heard outside of this courtroom. You are alone judges of the credibility and of the weight to be given to the testimony of the witnesses. Remember, ladies and gentlemen, that you are not bound to take the testimony of any witness as truth. You are the judges of the truth of the testimony, and I am the judge of the law as I and you all make sure that you capitalize court when you can replace judge in the sentence, okay? We'll get ready for 1 minute at 180 for your Q&A. 1 minute at 225 warm up before your Q&A mock. Starts in the middle, you all. What else happened?
Earl played his horn with the group.
Did you have any conversation with the other members of the band?
Yes, they were all friends of mine.
How long did you stay at center stage?
We probably stayed there until 1:30.
Then did you leave?
Yes.
Where did you go?
We went to the disco lounge.
Where is that located?
It is about 4 miles from center stage.
What did you do there?
We ate and drank.
How long did you stay there?
A little over an hour.
About what time was it now?
It was getting close to 3 o'clock.
Did you leave the disco lounge about that time?
Yes.
What, if anything, did you do there?
I drove to a gas station and called Ray Westfall and Stan Jensen.
When you got out of the car to make these phone calls, did you tell Weller who you were calling?
No, I did not.
Did you offer any explanation as to why you were making these phone calls?
I just told him we were going to a gas station because I had some calls to make.
What, if anything, happened after you made these phone calls?
I found out that the drug was available to me at the time.
From whom?
From Stan Jensen. So I drove to Portage.
Okay, and then we have on your 225 Q&A some names that come out. You have Wilma Louise Harvey, Star Route 1, Plymouth, Highway 27, and Washateria. There's the first part of that. And this is going to be 225 Q&A for your mock for 5 minutes, and it starts at the very beginning. Final exam. State your name, please.
Wilma Louise Harvey.
Tell me how old you are, where you live, and what family you have.
I am 36 years old, have 4 children, and I live on Star Route 1.
With whom do you live there?
With my husband.
How long have you and your husband been married?
Going on 20 years.
Is this your first and only marriage?
Yes, it is.
What kind of car were you driving when this accident happened?
It was a 1996 Plymouth.
How long had you owned it?
I think we had it about 3 or 4 months before the accident happened.
Do you remember what you paid for that car?
We paid about $650 for it before it was financed.
You bought it from a used car lot?
Right.
Did the car run all right? Do you know?
It ran perfect.
After the accident was over, what part of it was damaged?
The back end was smashed up.
Do you mean the trunk?
Yes, and the glass in one of the lights was broken.
Was there any other damage to your car?
It broke the front seats, just laid them back.
Did you have the damage to your car repaired?
No, we did not. The car is at our house. You can see all the damage that was done to it.
Will you tell me how the accident happened?
I was going north on Highway 27 to the Washateria.
How near is that to the place where they sell those dishes?
That is 1/10 of a mile where I put my blinker light on to turn off at the Washateria.
I assume you went out and measured that distance?
My attorney and I did.
Which blinker did you turn on?
The left-hand blinker.
Did it work?
Yes, it worked.
How do you know that?
It blinks on the inside.
How do you know whether it was blinking on the outside?
Because my husband is a mechanic also, and he keeps those things up.
You say you made the signal and were driving on up the road. Just tell me what happened.
And then the truck hit me.
Had you reached the place where you were going to turn?
Yes, I had.
What happened to you next?
There was a car coming, and I couldn't make the left turn. Then the truck hit me and knocked me off the road before I could even get it stopped.
You were not completely stopped at the time you were hit?
I was almost to a stop.
You had not turned your wheels yet?
Not quite.
Because when you were hit, you moved on straight forward.
That's right.
Did you pull the car over to the side of the road and then come back?
Yes, sir.
Did you talk to any of the men in the truck?
We talked a little.
Would you tell me about that conversation?
There wasn't very much said. When we finally did get down there, he asked if anybody was hurt, and I told him yes. I told him my neck was stiff and my shoulders hurt.
Which one of the men were you talking to?
I don't even know which one it was. I had never seen the men before in my life.
Do you have any recollection as to whether they looked alike, had difference in ages, or anything?
Yes, there was one older than the other one.
Do you remember whether the one you were talking to was younger or older?
It was the young man I was talking to.
Did you talk to the older man?
I don't think so.
Do you remember anything he might have said?
I'm pretty sure it was the younger one that did most of the talking.
Do you remember anything else in particular that either of them said to you?
About the accident?
About the accident or anything about it?
He just said that he thought he should have had the brakes adjusted before he started the trip.
Did he say that they didn't work or anything?
He didn't say. That's all he said.
Can you remember anything else that was said?
He asked me if I was going to the hospital, and I told him I was. That was when the patrolman was there.
Do you remember him talking to the patrolman?
Yes, I do.
Do you remember anything that was said between them?
I couldn't hear what they were saying.
The conversations you have related were ones you had directly with one or both of the men?
That's right.
Did they seem to be somewhat concerned about you?
No, sir, they didn't.
Did you seem to be in pain, or is this something that somebody might not know?
Yes, I was in pain. I couldn't straighten my neck.
When was it that your neck got stiff?
When I got out of the car.
Was it bothering you that day before the accident happened?
No, sir. I did not have any trouble with it.
What day of the week did this accident happen?
It was on a Sunday.
Was there much traffic on the road that day?
The usual amount for a Sunday afternoon.
You were moving along about how fast before you started to slow down to turn?
Approximately 40 miles an hour.
Do you think you did get up that fast driving through there that day?
They do have a speed limit there, and I had slowed down, before I put my blinker light on.
I was interested in how fast the traffic was moving along there.
There wasn't any car real close in front of us.
You slowed down to what speed before you put your blinker light on?
I don't even know what speed.
Did you go to the hospital from the scene of the accident?
No, I drove the car home and then was taken to the hospital.
Did you stay in the hospital, or what happened?
Yes, I did. I stayed 11 days.
What did they do for you there?
A little bit of everything. I don't know exactly what all they did do.
You stayed in bed a good bit, I guess, didn't you?
Some, but they let me get up.
Did they have any particular thing that they put you through or put you in?
I wore a collar the whole time I was up.
When you were in bed, did you take the collar off?
Yes, the nurse helped me with it all the time.
Was there anything else that they did for you?
They put me in traction. They also used heat on my neck.
Okay, so I'm going to shut this off, the first mock, and then I'll come back with the second mock. Okay, I'm going to separate the files. So that's mock number 1, you all.